In this section of the course, we're looking at comparative law. Comparative law is that process by which we examine two different legal systems, and we look at their differences and their similarities. And in this case, we start with Western legal systems, which is comprised of the civil law and the common law. Now, there are certain elements that we're going to contrast within the civil law and common law to show their differences between these two legal systems. Now, the first thing we're going to take up is origins. Where did it come from? Well, remember, common law is based on English heritage. It spread through conquest and colonization. Common law was never voluntarily adopted by a people. Instead, it was imposed upon them. Civil law has a different type of heritage. Civil law has Roman heritage. Roman heritage filtered through the French Civil Code. Remember, the French Civil Code is the most influential legal document in the world. Civil law has spread because of voluntary adoption by new states. As new states joined the international community, those states tended to adopt civil law as their basis. However, keep in mind that virtually every jurisdiction is actually a mixed law system. There are elements of the common law and the civil law in virtually every legal system. But let's start with structure. How are they structured? Well, common law is generally uncodified. That means there's no comprehensive compilation of legal rules and statutes. There's no book called the Book of Law. Common law does rely on statutes, which are legislative decisions, but it's primarily based on precedent. Precedent meaning judicial decisions. Those precedents are maintained over time through the records of the courts, as well as documented in collections of case law known as reports. In common law countries, the legal system is not organized in a coherent and clear structure. Its development tends to be very incremental, and it's not easy for a foreign lawyer to approach the common law. Civil law, however, is codified. Countries with civil law systems have comprehensive, continuously updated legal codes that specify all matters capable of being brought before a court, the applicable procedure, the appropriate punishment for each offense. Such codes distinguish between different categories of the law, things like criminal law and business law and negligence law. All of those are all found in codes. Civil law puts a great emphasis on system and structure. And one of the reasons that civil law has spread so widely is that there are similar patterns in the organizations of legal topics across different civil law systems. In terms of sources of the law, both sides agree that there are the same sources of law. However, there is some difference in interpretation of the relative importance of each source of the law. The sources of law are the Constitution, legislation, and case law. And those would be the hallmarks of both systems. However, in a civil law system, as we'll discuss, legislation is very important. Legislation represents the will of the people. And so therefore, from a democratic perspective, legislation could be considered the most important source of the law, even more than the Constitution. Case law also plays a role in civil law, but a much reduced role compared to the role it plays in a common law system. Let's look at legislation. Legislation in the common law tends to have a very narrow scope, and they are usually intended to fit into whatever existing case law there is. Civil law codes, however, are designed to create a comprehensive provision for an entire area of the law, such as consumer law. And a civil code will supersede all pre-existing law in that area. Maybe not so with common law legislation. Again, as I'm pointing out, case law plays a role in both systems. Common law places the primary importance on case law, and there's a strong reliance on precedent in establishing the law. Whereas the civil law considers cases to be important, but more as a secondary source of the law, to examine how other courts have interpreted the law, but not to make it the law. Now, civil law today, people who practice civil law are aware of the lawmaking function of the judiciary, and while they will accord some persuasive authority to court decisions, the force of precedent is much weaker in the civil law than it is in the common law. In the common law, we have a doctrine called stare decisis. And stare decisis means that a court that is subordinate to the other court that has ruled on an issue must rule in the exact same way, and they must follow the same rule of law. In a civil law system, a court that confronts a number of cases all seeming to say the same thing should follow that line of cases, but they don't have to. Now, in the civil law, we call this concept jurisprudence constante. And jurisprudence constante is similar to stare decisis, but not the same, because under the civil law system, there's a suggestion that a court should follow case law, but there's no requirement that it must do, as we see in the case of stare decisis. What's the judge's role? In the common law, the judge is an impartial referee. He's there to moderate the two parties. The common law functions as an adversarial system, a contest between two opposing parties, and the judge is going to moderate between them. It's actually going to be a jury of ordinary people without legal training that's going to decide on the facts of the case. The judge is going to determine the appropriate award or sentence based on the jury's verdict. Now, in the common law system, a judge is a VIP. They are the most important player. In a civil law system, the judge's role is to establish the facts of the case and then to apply the provisions of the applicable code. In a civil law case, the judge may be an investigator. The judge will question witnesses. The judge will play an active role in establishing the facts. And a judge is going to review all of that evidence and then decide based on his determination of the facts. Now, in a civil law system, judges are not so much VIPs. They are mid-level civil servants, professional bureaucrats. You go to school to train to be a judge. The central actor in shaping the law. In the common law, once again, it's the judge. The judge is going to create precedents, and the precedents to be applied in the decision of each new case are determined by the judge. Therefore, judges in a common law system have an enormous role in shaping American law. The judges are the one creating the law. Now, in the civil law system, it's the legal scholar. The judge may play a role in the case, obviously, but he or she works within a framework established by a comprehensive codified set of laws. And the most important player in creating those laws is the legal scholar. So the legal scholars essentially shape the law, which is then applied by the judge. In a common law system, the judge is actually creating the law. Juries is an element in which both sides differ greatly. Juries are vital to common law systems. The idea is the jury is an attempt to democratize the system that makes the legal system representative of the people. That's why when you get a jury of your peers. Those are people just like you, and we're going to rely on that jury to create a democratic form of a judicial system. These juries are rarely used outside of the common law. In the civil law, there is a focus not on juries, but on professional investigation and decisions, rather than leaving important decisions up to a random group of 12 strangers who are brought together based on the fact that they don't know anything about the case or about the law. Rather than doing that, instead, there's a focus on having professionals decide what the ultimate decision should be. So juries rarely used outside of the common law. Lawyers. Under the common law, lawyers have a very important role. They have the role of questioning witnesses and presenting written evidence to the court. Lawyers in a common law system are much more active. There's a big emphasis on flexibility and initiative. And lawyers in a common law system are not so intent on reading the law and following the law, but instead on shaping the law through their advocacy. In the common law system, we depend on the role of the lawyer as an advocate for his or her client. Under the civil law, lawyers are there more to inform and advise the court. In the civil law system, once again, there's a scholarly approach that shapes the mindset of lawyers. Lawyers there tend to be less pragmatic, less realistic about particular cases. They don't pay as much attention to the facts of particular cases, but instead prefer to think and argue in abstract categories and systematic contexts. So, in the common law, lawyers are generally seen as a profession, such as a plumber or a doctor or an accountant. Under a civil law system, lawyers are seen more as academics, scholars, people who've studied the law. Not so much on what they do, but what they've studied. Trials in a common law situation, a trial is accusatorial and confrontational. And a common law trial, as you've seen on numerous TV shows, is generally a single continuous hearing that lasts for a relatively short period of time. Trials in the civil law system are more of a process. They're not so much confrontational, but more inquisitorial. And it is not accusatorial, it's more of a collaborative effort. It's a process that occurs over multiple sessions in which evidence is gathered and weighed and discussed, and it generally happens in 10 or 20 or 30-minute increments. Finally, the trial, as we would refer to it, will end in a hearing where each attorney will be given 10 to 30 minutes to present their main arguments. So the trial is much more important in the common law system really than in the civil law system. Discovery of evidence. Discovery is what we refer to as that process by which one party obtains evidence from the other. And under the common law, discovery is extensive and expensive. Under the common law, attorneys are entitled to discover not just relevant evidence, but any evidence that may lead to the discovery of relevant evidence. So it's a pretty broad net that an attorney can throw. It's a key factor in litigation because the cost of litigation is driven by the cost of discovery. So in the common law system, before ever participating in litigation, defending a suit, or filing a lawsuit, the parties must discuss the cost of discovery and the extent of discovery. Now, under the civil law, evidence demands are when the court's function. The court decides what information each party should receive, not the lawyers. Discovery is very limited in a civil law system, and it's available pretty much to the extent that the court allows it. So discovery within a civil law system, much less expensive, much less extensive. Admissibility of evidence. Again, we've seen lots of TV shows in which the judge listens to objections and sustains them or overrules them. These objections usually involve evidence, the evidence that should be admitted, or that one party believes should not be admitted. These follow, in the common law, we have rules of evidence, and these rules of evidence are meant to be very restrictive. The idea is that a jury is a group that has no legal training, and therefore we have to be very careful about the information that we share with a jury. So in terms of the evidence that comes into the finder of fact, the jury, it's a very limited amount of the evidence will actually reach the finder of fact. In a civil law system, because there is no jury, all evidence is considered. Much more evidence is considered, because ultimately it's going to be a judge who's going to weigh the evidence, and a judge is aware of the evidence that is relevant and the evidence that is not. Finally, appellate review. Common law appellate courts can only review questions of law. The jury is the ultimate decider of facts, and at a higher level, even the Supreme Court of the United States cannot go back and review a fact decision. So if the facts are determined by the jury, that factual determination remains with the court for the rest of the life of the lawsuit. So in common law appeals courts, most questions that the judges face have to do not with the substantive facts, but instead procedure. Was the right procedure followed? Was the right evidence admitted? Was the right evidence excluded? Were the instructions to the jury adequate? Those are all the types of questions that a common law appellate court must review. Civil law appellate courts, on the other hand, can review both questions of law and questions of fact, meaning a civil law appeals court can go back and look at the evidence and decide that the underlying court got it wrong. So the analysis of civil law appellate courts can reach both procedural and substantive issues. But here's the rub. Is there really a difference? Now, once upon a time, when we were talking about comparative law, the entire focus would have been on the question of civil law and common law. But in today's environment, many would argue that the civil law and common law really constitute a single Western legal tradition. Most lawyers today agree that the traditional distinctions between the two traditions of the civil law and the common law have diminished. And many would argue that the idea of comparative law as comparing these two is outdated. Because, again, they're using the same sources of the law. It's just a matter of interpretation of which is more important. There are some legal traditions that both have in common. These are similarities between the two Western legal systems. And we'll start with this one. Law is separate from religion, morality, or other social norms. Although I do point out that law is often influenced by those things, but we think of the law as something different than morality or religion. and that's true in both the civil law and the common law. We know that in the Western legal tradition, the law is the most important vehicle for ordering society and resolving disputes. We use the law to organize our society and to assist us in the resolution of disputes. In both legal traditions, the law regulates the conduct of both the individual citizens and the state. The law applies to both parties. Only a narrowly defined set of facts are relevant to resolving a dispute. The relationship between the parties and the personal side issues are considered immaterial and should be ignored. And that's the same, again, in both legal systems. We want to rely on a narrowly defined set of facts to resolve the dispute. And finally, in both systems, dispute settlement is essentially a zero-sum game. One side will win and one side will lose. There is not an attempt to reconcile the parties, to get them to agree, to compromise. Ultimately, dispute settlement is about apportioning the amount of controversy to a winner and to a loser. And that's it for this lecture. Please let me know if you have any questions or need any additional information. Thank you.